Kennedy, all persons having anything to do before the Honorable, the Justices of the Appeals Court, now sitting at Boston within and for the Commonwealth. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is open. Please be seated.
Good morning. Welcome to the Appeals Court. I'm Justice Meade. With me today are Justices Shin and Tam, who will be the panel for all 6 cases. I know you've been here before. We've read everything. Each side gets 15 minutes. You needn't use all of your time. My best advice is to get right to the point. And with that, I'll call our first case 24P 953 Commonwealth versus Hunt. Mr. Herrick.
Good morning, and thank you, Your Honor. May it please the Court. I am Robert Herrick. I'm here for Sean Hunt. The question before the Court today is whether the defendant's motion for new trial raised a substantial issue that required a hearing. And I think more specifically, did the motion judge have an obligation to determine whether the Commonwealth destroyed files that were the subject of a pending motion in bad faith? I think that's ultimately the question that is before the Court. Obviously, I'm going with the procedural issue first, and I'm doing that primarily because I think it's very unlikely for me.
Can I interrupt? Why isn't this barred by direct estoppel?
For a couple of reasons, Your Honor, but primarily because the motion for sanctions was a different argument. It was judged according to a different standard. And most important...
Is there a separate notice of appeal from the denial of the sanctions?
No, I did not appeal from the denial of the motion for sanctions.
So that's not an issue before us?
That is not.
Okay, so let's get back to why this isn't barred by direct estoppel.
It's not barred by direct estoppel, Your Honor, because they're two fundamentally different motions. Substantively, they're different motions.
The only thing I saw a difference is an affidavit from counsel saying it was his opinion that the sentences for Mr. Todman were lenient. Well,
no, I think there's more to it than that, Your Honor. I think the most succinct answer I can give you is that if I were to have won the motion for sanctions, I would not have been able to go back into court and ask the judge, well, I just won the motion for sanctions, therefore I win the motion for new trial. Those are two different motions. There's two different remedies that I'm looking for. If I were able to do that, I think that direct estoppel would come into play. This ultimately is not the case.
Well, also just on the, what would be the prejudice? Right? Because what is the materiality of these two? You're looking primarily at the 2 drug cases, right? The district court drug cases that the witness pled out on. And in fact, at trial, wasn't there plenty of exploration into much more prejudicial, right? Arguably, that the issues that the witness who admitted, right? It was uncontested that about his participation in not being prosecuted as an accessory after the fact in the murder.
No,
right?
In fact, Your Honor, when Mr. Todman was asked, did you receive anything in response to, for your testimony here today, he actually said no. The prosecutor said, don't worry, I'll clean that up later, but when I call a police officer who will come in and testify that, yes, we agreed that we were not going to prosecute him as an accessory after the fact. But there's... the
evidence was heard by the jury.
There's another issue as well. It's that when he was asked, well, what do you do for a living? He said something along the lines of, I'm a baker. So for all the jury knew, he was a baker. This was an individual who for 10 years had been running a drug operation in Bristol County, and you can tell that from
So why wasn't that brought up in defense counsel's cross-examination, as well as the deal he had for not being charged as an accessory?
Oh, it was brought up, and it was met with a simple denial. So
that he had a deal?
That he had promised that had been made to him. That's correct.
It wasn't withheld exculpatory evidence then, right?
No. That the information that he had been offered, that deal, was certainly disclosed to defense counsel. And we don't dispute that in the least. What I'm suggesting, though, Your Honor, is that there are a couple of things that are going on when it comes to the prejudicial aspect of it. And one big prejudicial aspect is that if Mr. Todman winds up getting this incredibly lenient deal, and it is a lenient deal to have 2 drug distribution cases dismissed, as well as a simple possession case dropped down to a quaff after 10 years of being in the system.
But what evidence do you have, other than opinion, that those are lenient sentences?
Well, I have the statutory history of the quaff statute. The quaff statute says this is an ideal way of disposing of cases for first-time offenses.
I'm sorry, my question wasn't specific enough. What evidence do you have that ties this to some agreement that the Commonwealth made that resulted in these sentences, not just a matter of statistics?
Oh, well, again, not statistics, that's the legislative history. My issue, frankly, Your Honor, is that I asked for post-conviction discovery. This court,
right, and
this court
the
said I was entitled to it.
The files were destroyed, okay? So with destroyed evidence, you have to show a reasonable possibility that it would have included something helpful to the defense.
Well,
and not just surmise.
No, it is not surmise, Your Honor.
So what is it?
What is it is, first of all, he's stopped for an arrestable offense by a state trooper. Is he arrested? No, he's given a summons. He stopped again 4 months later. Is he arrested? No, he's summoned into court. Okay.
Right, but the state trooper explained, though, right, that the witness was in a car alone with his children, right, with children
Right.
present. And the state trooper took that into account, didn't want to arrest him in front of the children, and that's why he was summoned.
Right, the state trooper is a mandatory reporter. The sensibilities of the children are of less significance than the actual well-being of the children themselves.
But more importantly, this was before Judge Cosgrove in the evidentiary hearing on the first motion for new trial. He references this on record page 72, notes 3 and 4. So this has already been decided by him that there was no promises, rewards, or inducements other than the not charging him as an accessory.
No, but I think what has never been squarely addressed by any court really is the fact that I filed a motion for post-conviction discovery. The Commonwealth reported to Judge Cosgrove, we're sorry, we don't have these files. We destroyed them before the motion was even filed.
Right.
Before your motion for
That's not their position anymore. They were destroyed.
Right,
No one knows exactly when they were destroyed. If they were destroyed on schedule, it happened after the motion was filed. But the motion didn't indicate that in anything reference to those files that would have put them on notice. Is that not correct?
That is not correct, Your Honor. I specifically mentioned the 2 cases by docket number. So the issue I'm suggesting is that if I file a motion for 2 files in particular, I file them weeks before they're actually destroyed by the Commonwealth. And the Commonwealth misrepresents to the trial court when they have been destroyed, so that the trial court and motion judge, Judge Cosgrove, winds up believing that the entire thing is a moot point.
But Judge Cosgrove also says that this would not be the type of notation that you would find in a file in a district court case.
This court disagreed.
I'm sorry, what?
This court disagreed when I argued this case, and we're talking a number of years ago now. What this court said, well, what do you expect to find in this file? And I gave several examples, and now I've given the court an affidavit from the actual prosecuting attorney who handled the plea.
I think all we said is we gave you the opportunity to get discovery.
Right, but the opportunity to give me discovery, implicit in that is also the recognition that there may well be exculpatory material here.
That's the problem, is that you just have a theory. You need more than a theory.
I need more than a theory. I needed the files, Your Honor.
No, I understand that, but you have to have more than a theory that there is something favorable to you in those files.
Oh, no, but there is something favorable. The three things that I just mentioned to you, whether it was basically ignoring the requirements of a mandatory reporter, summoning an individual who was in default status on the second case.
And you think that's going to be in the district court file?
I think that if you were to look in the district court file, what you would see is the individual who actually authorized this plea. I do not know who authorized this plea. I've had to try to pull teeth to get even where I am today, just to give you the chronology. This chronology.
Authorized the plea in the murder case?
What's that?
Authorized the plea in the drug cases, you mean?
In the drug cases, yes, I apologize. So just to be clear.
It's probably unlikely it was the line assistant that was able to authorize the deal.
Right. What I suggested to the court the last time I was here was, I think that it is very likely that if there's exculpatory evidence, and I haven't seen the file, that it would say the homicide prosecutors would have said, we do not want a conviction in this case because we don't want this individual to be impeached as a drug dealer.
But is that information going to be in the district court file?
I believe that if in a district court file
that a superior, like a homicide prosecutor, is going to say to their line ADA, listen, give this guy a quaff. Or
yes, Your Honor. I've seen, or I can tell you this. I've seen in Boston Criminal Laboratory notations from homicide saying, "Do not test this DNA." When homicide wants something that's going to be beneficial to their case, they let people know. And
well, they would let their own ADAs know, and sure, maybe it's in the ADA's file, but I just.
But it's the ADA's file that I'm looking for.
Right, but.
And when I was moving for sanctions, what I was asking for was, all right, I'll accept the fact that these are destroyed. I can't do anything about that right now. So what I would like as a remedy is I would like to see the file from Mr. Todman's case. From Mr. Hunt's case, and also from his co-defendant, from Mr. Pittman. That was denied to me, and again, it was denied to me by a judge who was unwilling to at least recognize the basic fact that there was a misrepresentation that was made to the judge, to Judge Cosgrove, and Judge Cosgrove relied on that not only to his own detriment, but to the detriment of my client. Ultimately, Your Honor, what I would suggest is this is a case where where I have presented evidence, and it's taken me a long time to develop it, where the Commonwealth has now acknowledged that they misrepresented a material fact that the judge relied on in denying my motion for post-conviction discovery. I get told over and over again, well, you haven't met your burden. Well, of course I haven't met my burden because the judge relied on a misrepresentation of fact, of material fact. So it's Kafkaesque, frankly. It's a situation where I would suggest that ultimately this court has an option. It's to say Brady is entirely self-policed by the Bristol County District Attorney, or the courts are actually required to go in and play a meaningful role in enforcing Brady. And with that, if there are no further questions.
Seeing none, thank you. Mr. Nadeau.
Thank you.
Good morning, Your Honors. May it please the Court, Stephen Nadeau on behalf of the Commonwealth. Given the extensive litigation before and factual findings from Judge Cosgrove on the question of whether the Commonwealth suppressed evidence of an undisclosed inducement to secure Mr. Todman's favorable testimony, and in light of Judge Cosgrove's explicit rejection of that claim, Judge Yasayan acted well within his discretion in denying the defendant's motion without a hearing, both on the merits and as to the question of estoppel. Very briefly, I'd like to address the so-called misrepresentation from the Commonwealth. I note that the defendant does cite a line from Judge Cosgrove's extensive findings, which again is at least partially mistaken. That initial motion for new trial concerned 5 of Mr. Todman's cases, 2 of them that were resolved on that 2012 date, 3 other cases that had been resolved much earlier. And certainly the statement is true as to those 3. By the time the motion had been filed, they had been destroyed in the ordinary course. The other 2 files were destroyed in the ordinary course, but just a couple weeks or so after the filing of that first motion for post-conviction discovery. I would also note that the defendant does not cite to any particular representation from the Commonwealth that the judge relied on, whether the Commonwealth was mistaken or acting in bad faith or otherwise. There's simply no representation from the Commonwealth anywhere. Just this partially mistaken.
Is there anything in the record as to when the files were actually destroyed as opposed to when they were scheduled to be destroyed?
And I can respond to that a bit because I was actually the ADA who responded to the first motion for new trial and motion for post-conviction discovery. And I did I know I submitted our appendix as a supplemental record appendix here. I can supplement that with the memorandum itself, which references, again, those 5 files. I say the defendant's claim principally concerns these 5 district court cases.
Do we know when? Do we know when?
It would have been around that. I don't know the specific date, no. All I know is that by the time I asked for them, they were gone. And I can't say now when it was, but it was certainly after that.
It was after the motion was filed?
After it was filed, but that seems what the time. So I acknowledge that there was a couple of weeks where those files seems like they would have been retrievable, but I don't think we were on sufficient notice that we'd have to act quickly to grab them. Furthermore, even assuming there was negligent or inadvertent loss, again, due to the routine destruction, it's the defendant's burden to establish a reasonable possibility based on concrete evidence that the contents of those files would have produced something meaningful for his defense. And I think he has failed to do so again, and particularly in light of, again, the extensive evidentiary backdrop where all the principal parties, the trial prosecutor, the lead investigator, the trooper who had made the stops in the witness's drug case, as well as the officer who was part of the actual and compelling inducement and reward to Mr. Todman for his testimony. So all of that having been hashed out, there's simply no evidence. So not only is the defendant's claim speculative as to what those files might have contained, I think the record draws away from that or undermines that speculation, making it increasingly unlikely that anything in those files would have helped the defendant. And turning also to Justice Tan's question to the defendant earlier regarding the question of prejudice, that was a question that both Judge Cosgrove and the first panel addressed squarely, that even assuming there had been some pattern of leniency offered in exchange, and even assuming that might compel Todman to testify even more favorably than the explicit deal regarding his accessory for murder charge, he still can't show prejudice because the question of bias was so extensively litigated at trial. And that's from Hunt 1, I believe it's page 25, with that finding nothing in this second motion for new trial. Again, even assuming negligence or on our part, even assuming he had met that threshold burden, he can't make that ultimate showing then of prejudice. Again, looking at the record as a whole, the judge is saying, again, well within his discretion on both grounds, the merits and estoppel. If there are no further questions from the panel, I will be happy to leave it there.
Thank you. Thank you both. We'll take it under advisement. The next case is 24P74 Commonwealth versus McAndrew. Mr. Trundy.
Good morning, and may it please the court. Christopher Trundy for the appellant and defendant in the Taunton District Court, Eric McAndrew. I would like to address the issues raised by the district attorney in its brief, because the issue of whether or not the alleged disregard of a court officer's order is by itself a form of disorderly conduct, I think is inconsistent with the case law, and particularly the case law that they review. And it was not an issue, as you can tell from my brief and the record, that was raised at the time that I moved for directed verdict on this particular count. There was no suggestion that simply because there was an order to immediately exit the building that constituted disorderly conduct. I understand part of the problem is that in the statute it calls for riotous commotion and yelling. There was none of that in this case. It calls for engaging in physically offensive conduct. There was none of that either. So if you look in looking at the cases, there are a number of cases that refer to orders by officers that are relied upon. But in every one of those cases, where a conviction was upheld, it was also in conjunction with, at a minimum, yelling, drunken misconduct, other types of abuse. And the main case that is cited is Markovage, which refers to the fact that there was an order, and refers to the fact that the order can be relied upon. But that order was in conjunction with very extreme public nuisance, an individual with a megaphone having disturbed a number of folks. By comparison, and it is cited, Commonwealth Zettel, which is an appeals court decision from 1999, referred to a woman who refused to follow an order in Fall River to move her car while she was picking up her children. As the court said, repeatedly refused to do that.
Wasn't Mr. McAndrew told 10 times to leave the building?
Well, that was the testimony.
Well, this is a sufficiency claim, right?
Well, so what's interesting...
Is it a sufficiency claim?
Yes, it is.
So we have to look at the evidence in the light most favorable to Commonwealth.
Right, but the question of whether or not an instruction to put on a mask, which is what they said, and an instruction to leave the building is by itself disorderly conduct is the question, not whether or not there was, for example, in the record here is the mask mandate instruction, which says it's up to the judge as to what to do if somebody does not put on a mask. And he was not suggesting that. He was asking to talk to somebody about an accommodation. And what the front desk did is had him stand aside where he stood peacefully, without incident, until they sent out Mr. Kurt, who was a superior.
How is it different from the Carson case? That's the drunken college student that wouldn't leave after being repeatedly told to leave.
Well, number one, he was publicly intoxicated. Number two, he was highly abusive.
It's not an element.
Well, that's what the court cites, is that he was zigzagging around in response to the order to stop. And
the officer Kurt had to. He attempted to escort him. He grabs his elbow, and then the defendant fights back to the point that they're on the ground, and people who are trying to leave the courthouse have to get out of the way.
Well,
why isn't that tumultuous?
No, because first of all, he did not fight back, and this is the dispute between what Mr. Kurt said happened and what the video shows happened.
And to the extent there's contradictions in the evidence, those are the things that the jury sorts out, not appellate courts.
Well, I think it's different because video still, despite the broad Lattimore standard, there is still the requirement that the jury has to be a reasonable jury taking the facts in total in reasonable review.
Let's say we viewed the video and we think that it appropriately depicts what was described by the witnesses.
Then
it's
we
tumultuous.
lose. But
I appreciate your candor.
well, what's interesting, just as an aside or a footnote to that, of course, is that he was charged with resisting arrest, for which he was found not guilty.
Right.
And when I raised the motion, and I quote in the brief what the judge said is, well, there was an issue that became combative, is what he described, and that was a word that Kurt used in his testimony. But it is clear that what happened was that Kurt immediately drove him against a wall, turned him around, forced him down to his knees, and then used his full body weight to slam him on the ground. And so I think the question is whether or not it is appropriate to say, now if one views that and says, oh, well, being involved in a takedown, which is when we bring other people in. That's when other folks come and join in.
Six total court officers were there.
Well, there were 2 already there. There are 3, and then, but it's that point when everybody gets involved. And if the question is, at the time he seized him, was he seizing him for disorderly conduct?
Doesn't the SHAWN case really lower the bar for what constitutes tumultuous conduct within the confines of a courthouse?
Well, I don't think it. I think it still goes to the question of whether or not it's disorderly conduct. So, for example, if we're going to say that there's a different standard in a courthouse, and court officer says...
Just a different observance of decorum and solemnity in a courthouse.
But I would suggest to you that the evidence shows that he was not disorderly. Now, if Kurt testifies, oh, I told him to leave, first they claim that they told him to put on a mask, which was not the issue. He was asking about an accommodation. But
he was unwilling to show him his claimed medical excuse for not wearing a mask.
That's not true. That was never established.
That's what Officer Kurt testified to. He waved a paper around and wouldn't show it to me. And he said it was a private matter and that he was a citizen and he had the right to be here.
Well,
That's what the evidence was.
Well, what Kurt said was that he had been waving around the governor's no mask order, which of course is inconsistent with the video. And then he asked him what he was there for. And he showed him the top of a caption of the case that he was there to go to the clerk's office on. And then Kurt said that was for the purpose of obtaining a ADA individual, which Kurt never attempted to do. And at that point, that's when Mr. McAndrew did ask, and this is in the record, he asked for Kurt's name and the name of somebody else to talk to, and he was given the name of Kurt's superior and was typing that into his phone when he was then physically grabbed by Kurt, not for the purpose of arrest, but supposedly for some other purpose. And then at that point, Kurt testified that he decided that because he had not gone through security, he was a security risk and had to be taken down. And then in the course of taking him down, he said at trial, I'm arresting you for disorderly conduct. I would suggest to you that to extend this in this instance, to make this particular crime the effective remedy for this interaction between a member of the public and a court officer is a substantial extension of all of the cases we've talked about and all of the cases that are cited in the brief by the...
Do his actions qualify as creating a hazardous or physically offensive condition?
I would suggest that that only happens when Kurt decides to take him to the ground.
No, it's still during the pandemic. There is an order that everyone inside has to wear a mask or leave. He refuses to put on a mask and he refuses to leave. Why is that not creating a physically offensive condition?
Well, in fact, as is referenced in the record, the trial court had various recommendations for dealing with people who did not want or could not wear a mask in terms of dealing with accommodations and how those would be done.
But
And that was not done.
He's asked to step out of the courthouse so that he's not indoors without a mask in a small space. What's your understanding of what that means that's one way of proving disorderly conduct, right? Creating a hazardous or physically offensive condition. What's your understanding of what that means?
Well, I think that we are in untested ground on the question of whether or not an individual.
There's no case you're aware of that.
I'm not aware of, honestly, I'm not aware of a case that, regarding masks that is similar to this. And so, but I don't think.
Not a case regarding masks, a case regarding what it means to create a hazardous or physically offensive condition.
Well, I don't think, I'm not aware of anything that's parallel to to the way of characterizing it here, and I'm not sure that was, I mean, granted, the theories of the case are varied in this, and we're looking at a statute with multiple prongs, but the thing is this, that if that was a hazardous and offensive conduct, he was not instructed to step out when he first went to the front desk. He learned that there was still a mask mandate for the court, and they told him to step aside. Nobody said, please step outside. It only became a question of him stepping outside when he started transcribing the name of Kurt and his supervisor, who he couldn't talk to because she was not available. So I would suggest to you that that becomes an ad hoc reasoning, because that's not what precipitated, that his behavior up to that point was in conformance with what was permitted by the court officers at the front desk. With that, if there are no other questions, I will
Thank you.
rest. Thank you.
Mr. Amaral.
Good morning, Your Honor. May it please the Court, Christopher Amaral for the Commonwealth. So, just to clear up a little. So, the Commonwealth's theory at trial and here wasn't just based on the fact that the defendant, refused to leave the courthouse after multiple charges, although that, I think, by itself would have met the standard under the disorderly conduct statute. It's taking the combination of everything that happens. I think if you look at the case law in the disorderly conduct universe, there's this kind of building up of, there's usually a gradual escalation of behavior. There's usually, it's taking in everything and looking at it from a 3,000-foot view. And here, like Your Honors mentioned, you have this defendant, he walks into the courthouse, a CO tells him, okay, well, you say that you have a medical exemption. I'm going to talk to somebody who's higher up on the food chain, on the chain of command. That person who was in charge of security for the entire building comes down while he's in there. And the first thing that the defendant says to him is, do you have to wear a mask in this place? And the CO says, yes, you do. You absolutely have to wear a mask in here. He mentions that he has a medical exemption, but he doesn't give any proof. He doesn't have any kind of paperwork. And the CO goes as far in his testimony saying, he doesn't even tell me what his name is. So he knows nothing about this person. He has a piece of paper with the trial court, just says trial court of Massachusetts at the top. He has no idea what that means or what that is. And after, like the transcript says, after 10 times of telling him to leave, and Your Honors viewing the video, if you've watched the video at this point, the CO turns to the door, and you can see him gesturing to the door multiple times. He even goes as far as to go to the door, opens the door, and he's gesturing, come on, let's leave. And only at the point where you can see that there's kind of like frustration between the two. And then the CO tells him, okay, this is, he doesn't say this is the last time, but he says, I'm going to physically, if you don't leave, I'm going to physically remove you from the building. I'm going to physically, and he says that in the testimony, although you can't hear it from the video because there's no audio, he says, I'm going to physically remove you. At that point, he says, the defendant says, I'll leave when I'm ready. Then that's when the CO takes his elbow, and according to CO Kurt, that's his that's what he's been trained to do. He says, when I'm trying to escort somebody out, he says, I'm not arresting this man. I'm not trying to take him down. I'm not trying to arrest him or detain him. I'm just trying to lead him out of the building. And at that moment, then I guess part two of the disorderly kind of universe of this, if you're looking at the whole scene, then the elbow comes up. And if you're looking at it from the angle of, the court officer, he's here, his face is kind of looking this way, and then an elbow is coming, near his face. And so he immediately takes action, pulls him towards the wall, and at that point, then the other officers come in, and then he's...
If the video actually contradicts the testimony, does that matter?
I don't, it would matter. I mean, if your honors looked at the video and, the testimony of the officer was, I was there for 5 minutes and I told him to leave 10 times, and he threw an elbow, well, I won't say throw an elbow, but he put an elbow up, right, and near my face.
If the supposed contradiction was one of description or subjectivity as opposed to an objective fact, like in the Vaughn case, would it still make a difference?
If it was a matter of, like a matter of degree,
the officers described the conduct in a certain way, and that one could look at the video and think that it's not exactly that way, as opposed to the fact that Mr. Vaughn couldn't have committed the crime because he was incarcerated at the time.
I think at that point, I think it's still a jury question. I think it's still, if...
I wanted to ask Mr. Mark, who wrote the brief, because you may know he argued that 39 years ago.
Well, I don't know anything about that, but yeah, I still think that it would be a jury question, unless it was just obvious that the thing that was being described, if he said he threw a punch at me and he was yawning, maybe that, like a degree, maybe that's something that you could look at. But if I say he threw a punch and it was kind of like a very loose punch or something, or just kind of like, I don't know.
Let me ask you something different then. What if we remove the entire, we'll call it a fight, if we remove the fight from our consideration, is there still tumultuous conduct?
I think there still is. If you look at the Markevich case, looking at where I think in that case you have to look at the environment. There, it's not a courtroom. It's not a solemn, area where this court has said, the threshold is very low, exceptionally low for what is tolerated for disorderly conduct. There, in the Markevich case, you're in the middle of Salem on Halloween, and anybody who has ever been to Salem on Halloween knows that it's very boisterous, just as a baseline. And this guy is, has a bullhorn, and he's, kind of being combative. And then in that case, the police go up to him, kind of similar to here, like multiple times. I don't know if it's exactly 10 times, but they go up to him multiple times, and they say, hey, listen, we've gotten multiple complaints about you. You're on your bullhorn, and so we're going to, we're going to take your bullhorn, and then that's when he starts acting. But one thing that's important to know about the Markevich case is that in it, it says, the court says, the words are failure to, obey a police officer is included in the definition of tumultuous. And it's in the court's analysis, they said, well, it seems like that's what the trial judge was looking at. There's only just that little snippet of did he or did he not disobey the lawful court or the lawful police officer in that case? And the reviewing court said, yes, that's enough, right? It wasn't necessarily the fact that he's on a bullhorn, there's a crowd. The crowd was kind of ready-made, if you will. And then further cases, there are two cases that I found kind of in the very, in the days leading up to this argument that I haven't cited, but I'm happy to give the citations to the court. Commonwealth versus Chisholm and Commonwealth versus Coleman, where they're both cases where a police officer pulls over a car and the officer tells them to get out of the car. Both people refuse to get out of the car. One, it's pulled over because there's a license plate isn't there. One is a speeding ticket. And in both cases, the lead up of, refusing multiple times to leave, get out of the car, That's the thing that, you know, this court looked at and said, okay, well, you know, that's part of the disorderly behavior, the tumultuous behavior. After the officer's attempt to arrest, there's other, you know, more extreme behavior of trying to resist arrest. And I think in both cases they were convicted on resisting arrest, whereas here, not. I think if there are no further questions from the panel.
Seeing none, thank you. Thank you both. We'll
Thank
take
you.
it under advisement. Our next case is 24P607, Commonwealth versus PA. This case is partially impounded, so do not use the victim's name. Mr. Conley.
Thank you, Your Honors. May it please the Court. Alex Conley for Mr. Pa. One of the main issues in this case involves the corroboration or credibility of police officers as opposed to other witnesses as it relates to prejudice in this case and the entire context of the nature of the error. I think that's important to keep in mind when thinking about this case because I think it could be easy to say, well, it's just a simple something the clerk said that was wrong and that's it, and that's the end of it. How is that going to cause prejudice? However, there's jury instructions, there's jury questionnaires often address, are you more likely to believe the credibility of a police officer than another witness? Do you have certain feelings about police testimony or police witnesses?
There wasn't any police testimony in this case.
And that's exactly the issue, Your Honor. Because there was no police testimony, that's why the severity of the clerk's indication that a sergeant of the Lowell Police Department swore to the complaint injects police testimony into a case.
Just clear up the standard of review here.
Yes.
There is no objection to this, so we're not reviewing for error beyond a reasonable doubt. It's substantial risk, correct?
So it's interesting, Your Honor. I've tried to review the case law for this kind of issue to see if there's ever comes up. I only found basically one unpublished decision, which I cited, that shows that this is just reviewed for substantial risk for a miscarriage of justice. Because it's extraneous information injected into a case, it's not an evidentiary issue or another.
Look, I mean, is there a case that says a criminal complaint being read at the beginning of trial is extraneous?
No, Your Honor, 'cause I don't think there's ever been a case where this comes up. But it is, in my mind.
The general rule is that if defense counsel doesn't like what's going on, he or she has to object. Because you know why? That gives the judge the opportunity to do something about it then when it matters.
Your Honor, the reason that this presents an interesting issue in this context is because in extraneous information cases, in a post-verdict inquiry, when the judge didn't have an opportunity to do anything, there's a standard set up. There's a whole framework laid out as to what happens. And so that's why this presents a different issue, because there is a framework when the judge doesn't have that opportunity in a post-verdict inquiry case.
Well, the judge here, though, I mean, the model jury instructions say, right, that the complaint is not evidence. And he instructed the jury that, actually, I think he said that more than once. And not only that, he actually says, and this isn't part of the model jury instructions that I'm aware of, that the evidence, and this is trial transcript 123, the evidence consists of the testimony of the witness that you heard. There is no other evidence.
Yes, Your Honor, I'd agree that there is proper instruction given as to the complaint not being evidence. I don't think that is going to be dispositive, that this couldn't nonetheless be an error, whether in either standard of review, I think, that whether it's reviewed for whether or not the Commonwealth has shown a prejudice beyond a reasonable doubt or substantial risk of a miscarriage of justice, given the nature of the error in this particular case. So as far as the nature of the error is concerned, I think it's important to recognize that this was something that shouldn't have been presented to the jury in any event. It's important to see that the jury should not have been told that Sergeant Boyle swore this complaint to the clerk magistrate.
Well, let's assume that's true. The Commonwealth did nothing with that evidence, or that information, excuse me, because they didn't say, you have to believe this complaint because this nice police officer swore it out.
That's correct. The Commonwealth didn't, but the defense attorney made substantial, basically the whole thrust of their case was the lack of corroboration. They say in their closing argument, there was no police corroboration here. It's just one person's word versus that's all you have.
And the Commonwealth didn't counter that with, no, well, we have this police officer, Boyle, who swore out the complaint. There was none of that.
Correct, certainly not.
Other extraneous information about sentencing, that wasn't read to the jury.
No, Your Honor, it wasn't. I suggest that goes into the analysis of prejudice, certainly, but I do think that in this circumstance there is more to it than that. And one thing area of law I cite to in my brief that I think is analogous to that is the search warrant context, where in many cases, I cite Saposnik and McCollum, I believe, it's found to be error and prejudicial error at times when police testify as to the circumstances leading to the issuance of a search warrant when that's not issued. So what they say is that's not relevant information, the same way that the swearing to the complaint is not relevant to issue and gives an air of credibility to charges. I don't think it's a requirement in those cases generally that it has to be argued thoroughly.
Isn't it more like an indictment, though?
I don't think it is, and I think it's more like, because an indictment says the grand jury came back with the indictment, right? The grand jury...
And it's signed off by an assistant district attorney.
Correct, and that's the prosecutor itself. But the prosecutor itself is different than the police officer, and that's why going back to...
They're all part of the same team.
They are, but when I'm going back to my initial statement in this argument here, there's no questions posed to a jury on the jury questionnaire, and in every jury trial asked the jury if there's an officer involved, are you more likely to believe something is, the case is more credible because an assistant district attorney is offering the evidence. People in the jury are more likely to take an additional look at the credibility of a police officer, and that's why that's instructed.
And you assume that would be tinged with some positive feedback about the police.
Right, that they'd be more credible by the nature of their position as a police officer.
This is in Lowell, right?
This was in Lowell.
Yeah, okay, thanks.
Nonetheless, people still have this outlook toward police officers generally, and there's a reason that, like I said, there's a reason that comes up in every jury trial if there's officers involved. And that's one thing where the judge didn't instruct the jury as would have been done in a police officer testifying case. Understandably so, because there was no police officer testifying, he wouldn't ask the jurors, are you more likely to find a police officer to be credible? But where there was something before the jury, not in evidence, but from the clerk saying this complaint was sworn to by sergeant of the Lowell Police Department in front of the magistrate, in front of the clerk, assistant clerk magistrate, that's the kind of thing that would have helped cure the potential to prejudice.
So should there have been a voir dire question to the veneer on whether they're more likely to believe a complaint when it's sworn out by a police officer?
I mean, that level of specificity obviously wouldn't come up almost ever, unless...
This has never come up ever.
Exactly. Unless this court were to endorse this kind of reading of the complaint by the clerk that says it, then I don't think it would be necessary. But if this court were to endorse that, however, and say this is fine, maybe we wouldn't need something, or people would be, obviously it would be incumbent upon attorneys to raise that issue at the trial level.
Why isn't it adequate that the judge instructed that the complaint that the clerk read against the defendant is only an accusation? It's
So
not
I think
evidence.
the question becomes what is the complaint in and of itself? Is the complaint just the fact that somebody was charged with this? Here, the complaint is that this person committed this offense, or does it go into, would a regular juror, any juror understand that what the judge is instructing on is the complaint not being evidence includes the swearing to of the complaint? Obviously, if...
The judge also told him that the defendant has denied the accusation. That's extraneous, too.
Well, I think the plea of not guilty is part of the pleading not guilty.
Well, if he said he pled not guilty, I'd feel differently. But he said he has denied the accusation. And Mr. Pa did not testify. So that seems to be extraneous as well, in your client's favor.
Certainly, and Your Honor, if it wasn't in my client's favor, it might be grounds for a different type of objection or a different type of issue. Obviously, I wouldn't be bringing that on appeal.
But we're looking at whether there's a substantial risk of a miscarriage of justice.
Certainly, Your Honor. And I do think just in the nature of this case specifically, with the single testifying witness who was a civilian witness, no evidence that witness ever reported anything to the police. And an interesting, ironic twist of the transcript was that the defense attorney actually wanted to have a police witness there initially and determined not to call them after they didn't show up on the initial summons. But in the actual evidence itself, no police officers, no police testimony, and defense counsel strenuously argued that the lack of police corroboration is what should make you, the jury, find my client not guilty. That's where the substantial risk of a miscarriage of justice under that standard of review would come into play. If there are no further questions, I'd rest on my brief.
Thank you.
Thank you.
Mr. Ferreter.
Good morning, Your Honors. May it please the Court, Timothy Ferreter, Assistant District Attorney from Middlesex on behalf of the Commonwealth. Just addressing in terms of questions that are asked to the jury, I think an important one in this case is that can they follow the presumption of innocence? All the jurors in this case said that they could, and they were properly instructed by the judge that the complaint is not evidence. So you have a jury who does say beforehand that they can understand that there is a complaint, but that they can follow the law of the presumption of innocence and disregard that and determine it based on the facts of this case. Furthermore, the standard review in this case, if there was an error, which there wasn't, would be substantial risk. That's pursuant to Commonwealth versus Fredette. In that case, during the trial, a juror passed a note that he had seen an interview. The defense attorney didn't object, and the review in that case was substantial risk. And then I think I covered most of my points in my brief, so I'd be happy to take any questions if you have any.
Is it regular practice to recite that the complaint was signed by police officer so-and-so?
In my anecdotal review, I flipped through some of my old district court appeals, and I saw it in a couple cases. I think the majority I did not see it, but I did see it a few times. But that's my non-scientific study on this, so I don't have a better answer than that, but I did flip through a few cases.
Would there be any harm if we suggested they leave that part out about it being sworn by a police officer?
I mean, I think probably not. I think it's just part of the formal introduction of the case, just like we have the court officer here introduce the appeals court at the start of the session. So I think it just adds to the gravity of the session that the complaint's been sworn, but he has denied the accusation and puts himself before the jury. So I don't see the harm either way. If there are no further questions, I'll rest on my brief.
Thank you. Thank you both.
Thank you.
This one, take another one. Might as well go with another one. The next case is 24P852, Department of Children and Families in another versus mother in another. Yes, it should be father. Ms. Healy.
Thank you, Your Honor. Your Honors, may it please the Court. My name is Julia Healy, and I represent the appellant father in this matter. The facts, law, and requests for relief in this case are very simple. Since at least 2022, my client has been seeking parenting time with his son. Despite 2 juvenile court orders mandating that time, in addition to DCF regulations, policy, and case law, DCF only provided 3 visits in 18 months.
But they fixed that, right?
They provided 3 visits, Your Honor, between August and November of 2023.
The judge found that DCF had abused its discretion and they had to reevaluate it, right?
Yes, sir.
Okay.
So the court ordered visits in both, I believe it was December of 22, and they ordered visits. DCF did not comply for 6 months. My client was then forced to file a motion to compel in May of 23. A month later, the court again found that DCF abused its discretion in refusing to give sufficient parenting time and ordered DCF to comply with its own rules, regulations, and the case law mandating those visits. DCF did not provide visits then again until August of 23, provided 3 between August and November, and then provided none between November of 23 and May of 24.
When did he move to the different secured facility? Was it during that time period?
Yes, Your Honor. I believe it was after November of 23. The court did find that DCF provided or sought to provide 3 visits after November of 23, but DCF should not get credit for attempting to do something it has illegal.
If they don't permit visits in the seclusion unit, or if they were to permit them, that they had to, the father had to be shackled, is it unreasonable for DCF to say that it wasn't in the best interest of the child to see their father shackled in the seclusion unit?
First of all, Your Honor, I don't believe there was evidence that the child wasn't allowed in the seclusion unit or not that I found in the RA anywhere.
Well, there was I think one of the visits was not able to happen because in May of 2024, I think the father had gotten into a fight, right? And he was in lockup, so they couldn't actually bring the child to see
There was
him.
an altercation, yes,
Right,
Your Honor.
Right. And then in April of '24, that was when he was transferred to another facility, right? And
I
then
believe-
and then the visit couldn't happen because he wasn't where they thought he was going to be.
I believe the evidence was, Your Honor, that there was an altercation, but and that he would be in shackles. There was no evidence that he couldn't be shackled under a table or that the child wouldn't see the shackles. There was no evidence that they tried again 2 days later or whenever he wasn't in shackles. When he was moved to another facility, there was no evidence that they called and said, okay, when will he be settled in? When can I bring the child? The point is DCF's almost glib attitude that, oh, he's in jail for 7 years, this doesn't matter. That's not okay. They needed to do these visits. And if there were little bumps in the road, which I agree there were little bumps in the road, that really doesn't matter. 3 visits in 18 months. We need to keep going back to the fact that they violated 2 court orders. They violated their own regulations, 110 CMR, and I can cite them. I'm sure Your Honor knows them.
Counsel, can I ask, and what in your mind, well, I guess 2 questions I have, at least 2. One, the first is, what in your opinion would be considered reasonable in terms of, visits and contact between the child and your client? And secondly, what is it that you're really looking for in the sense, and maybe you should answer this question first, because I think it's a little more sort of a global in the sense of where's this going? Because my understanding, right, is that a week from today, there is going to be a termination trial, right, of your client? Am I right about that?
If I may go off the record?
Well, I think it was
would
sent,
be off
I
the
think there was
record.
a status report that was sent to us.
That status report did not include all of the information, which was a little shocking to me. If I may go off the record, I was told by the trial lawyer in this case that DCF itself is seeking to continue that trial. I don't know, this is coming from the trial lawyer. But my understanding is they're moving for continuance. That was not
That doesn't mean they're going to get it, right? I mean, right now, there's a
We don't know.
scheduled, as far as we know, right now, there's a scheduled trial, a termination trial, right, for your client, as well as the permanency, the 29B, that got rescheduled from March to also be heard at the same time as the trial in a week.
First of all, my brother submitting that letter was a little shocking to me. I don't know under what rules of this court he is allowed to simply present this court with information off of the record. If Your Honor would like to take that information, my answer to that would be that we don't deal in unknowns. None of us deal in unknowns. We have, like Your Honor said, we have no idea if that trial is going to be held. We have no idea if the court's going to terminate my client's parental rights. And as you know, Your Honor, until his parental rights are terminated, DCF has to make reasonable efforts. In May of 23, the court had a trial. DCF wanted to terminate my client, and the court said, no, you
Right,
have
because they
not
hadn't
made
made
reasonable
reasonable
efforts.
efforts.
They still
Right.
haven't made reasonable
Right.
efforts. So if we're speaking in unknowns, my belief would be that the court may do the same thing. To go back to your questions, the end of my little elevator speech was going to be, what we are seeking is very simple. I have told my brother this over and over. All we want is visits, is parenting time. He has a constitutionally protected right to a relationship with his child. He has a constitutional, DCF has to make reasonable efforts to both reunify him and to protect that parent-child relationship. So say what you want about the fact that he is incarcerated for a certain number of years, which is not forever, so we don't know that he will never be seeking. My brother, a little disingenuous, I guess is the word, in his brief when he said my client is not looking to reunify. He never said that. He said through counsel he could not reunify now, which he can't. But that doesn't mean he can't reunify in the future. So what we are looking for, Your Honor, we are looking for visits. We are looking for what DCF by its own regulations, once a week, no less than once a month, which would be 18 visits in 18 months. They've given 3. They are 6 times less than what they are supposed to be.
Why isn't this properly addressed by the judge in the first instance at this point?
By the 2 court orders that they violated? Because, well, number one,
Well, I mean,
they violated them.
your
but-
client has the opportunity to seek review of the department's efforts, right? The order we're reviewing is quite dated at this point.
It's May of 24, Your Honor.
Right, it's
So
a
it's
year
a year old.
old,
So under 29B, my client has a right to appeal an order made by a court at a permanency hearing.
That's right. So you appealed the order, which 29B allows you to do, to a full court. But now you have dropped the first argument in your brief, in your
You were
appeal.
forced to, yes, Your
That
Honor.
goes to the permanency order. So now what we're left with is reasonable efforts. So had that been reasonable efforts finding been made as a standalone order, that would not be appealable to the full court, correct? That would have to go to the single justice.
But us being forced to dismiss count one doesn't mean that the permanency hearing didn't exist. My client is appealing, my client's current appeal is under that permanency order, is an appeal of that permanency order. We are no longer able to appeal the court's determination of the goal of adoption because
It changed.
because it did not change, Your Honor. My client's, the DCF's internal goal changed. DCF decided to place my client's son with a known domestic abuser and did not, and is no longer terminating mother's parental rights, one would assume in exchange for mother agreeing, and therefore my client not being able to seek reunification with the mother. But despite whatever foot dancing DCF did on that, this appeal still comes from that May 24 permanency hearing. And under 29B subsection E, we have every right to stand here and appeal it. We just are appealing a different part of it. We are appealing the reasonable efforts determination part of it. And if the court is going to talk about whether or not there was a reasonable effort determination in June of 23, I don't know if that seeks the court interest, but there is not. There is nowhere on the docket that the court made a reasonable efforts determination in June of 23. The court, in a finding in July of 24, said, yeah, I made this reasonable efforts determination. You can't do that. The docket controls it's not on the docket. So we have a right to appeal it. The time goes back to April of 20. DCF certainly has not made reasonable efforts since April of 20 to have parenting time with my son, with my client's son.
What about the 29C exception?
Thank you, Your Honor. I'm glad you brought that up. There is an exception. It absolutely does not apply in this case. The exception very clearly in black and white states that if the court finds that a parent subjected a child in the home to sexual abuse, DCF does not need to make reasonable efforts. In 5 years, the court never made that finding. The court did make a finding that my client was guilty of crimes in relation to sexual abuse of a child. But despite what my brothers may say, it never made a finding that that child was in the home.
Okay, no, the judge found that he was convicted of sexual abuse of the sister and that both the child and the sister were removed from the home because of the sexual abuse. Why are those findings not sufficient for us to conclude the
Because she
exceptional
never
clause?
found that they lived in the home together. They were both removed from the home.
At the same time because of the sexual abuse. The judge made that finding.
The judge made that finding, but the judge never found, and I've scoured the record on this, there was no finding that it's a stepsister, I also believe, not a sister, but there was no finding that my client's son and this other child lived in the home at the time the abuse occurred. And that's what it needs to find. If the court finds that the parent subjected a child in the home to sexual abuse, we do not know that child I lived in the home at the same time my child's client did. And as my brother very well stated, when a statute is unambiguous, it needs to be interpreted per its ordinary meaning. The client, not only did the court not make that finding, and we can talk about timelines all we want, the court made a conclusion of law at RA 3536 that DCF was required to make reasonable efforts.
Right, but it seems reasonable to assume that when there's a 51A report filed alleging sexual abuse of the stepsister, and then the children are removed, that this occurred within, she was only 5 years old at the time, that this occurred within some reasonable amount of time before the 51A report.
I don't know that, Your Honor. You don't know that.
Well, see, what's going to happen is whatever we decide in this appeal goes back to the trial court, and there's the department or the child's going to make this argument, right?
Let them make it. And maybe the timeline is for them, maybe the timeline is for me. I don't know. But we can't stand here and talk about what...
Well, okay, but so then why is going back to my earlier question, why is the appropriate remedy not to file a motion in the trial court?
Without speaking too much outside the
For
record.
a more
DCF
current determination of reasonable
DCF
efforts.
basically forced us here. My client went twice to the juvenile court. They got 2 orders. DCF refused both of them. No matter how much we tried, we could not get DCF to provide visits. We have a right to be here, and at some point, we needed to come here and explain to this court what was happening. The juvenile court orders weren't getting it done. Nothing else was getting it done. I also, just quickly back on our other point, not only did the court make a conclusion of law that DCF was required to make reasonable efforts, which I think clears up any ambiguity about whether or not the court thought that the exception applied, it also evaluated DCF's reasonable efforts on at least 2 occasions, at least one of them being after father was convicted. And at that point, the court made a reasonable efforts determination, did not say the exception applied, and did not make the finding required in 29C Part 3. In fact, the court never said DCF was excused for making reasonable efforts and did the exact opposite.
So I want to go back to your argument that that our review has to go back to 2020 because there are no, and I have a question, maybe this is a question better addressed to the department, why there were no permanency hearings for 4 years. But regardless, there was a trial, right, 2023, and you had said earlier, and the record reflects, that the judge didn't terminate your client's rights because they found the department had not made reasonable efforts.
Yes, Your Honor.
So you would concede, you would agree that she made a finding?
No, I'm sorry, I'm not conceding that. I'm conceding there was a trial in May of 23. My client's rights were not terminated. The court did not make a finding as to reasonable efforts. And if you look at the docket, it's simply not there. And the law is clear. The docket controls, if it's not on the court can't 14 months later in findings of fact for a different hearing say, oh, wait, yeah, I did make that reasonable effort. No, it has to be on the docket. You can talk about even timely on the docket, but it isn't on the docket at all. It's not even like the court went back and put it on the docket. There was no reasonable efforts finding made in June of 23. Even if there were, which there absolutely wasn't, but it would have been a finding of no reasonable efforts. So I don't see how this even helps my brother. There was clearly no reasonable efforts made between 4/20 and 5/23.
But there was a finding then, though, let's just say.
There was not a finding, no.
Well, right. So your argument is that where our inquiry has to go back to 2020.
Yes, Your Honor. April of 2020 is the look back.
So let's say the trial goes forward next week. And by the way, that's not outside the record, that's part of the docket. You're saying we and the trial court should be making concurrent determinations of reasonable efforts?
What's outside the docket, Your Honor, is my understanding that DCF is
Okay, let's
moving
just
to continue that
assume
trial.
we will know next
Okay.
week whether the trial is going forward. And you're saying in that case, there's still relief that we could grant?
Yes, Your Honor, because until my client's rights are terminated, DCF must make reasonable efforts to reunify and to solidify that parent-child bond, which at this point really needs to be.
Okay, we're going to leave it there. Thank you.
Thank you, Your Honors.
Mr. Price.
Good morning. May it please the Court. Matthew Price on behalf of the Department of Children and Families. The Department is asking this Court to affirm the decision of the lower court that made a determination that reasonable efforts were made by the Department. The Department's also asking this Court to allow its joint motion to supplement the record and also to allow Father's motion to dismiss his first argument. The relief that Father seeks is available next week in the juvenile court. That is...
Does that prevent them from asking us for relief here?
I don't think
What's your position? Can you just speak to that particular issue?
Sure. I don't think that prevents this court from making a decision. The outcome of this court is based on the order from 2024, and my position is that the next reasonable efforts determination that the court makes will supersede that. So whatever the court decides here, the most current reasonable efforts will be decided next week.
Assuming it doesn't get continued.
Correct. And
Did the department file a motion to continue?
not to my knowledge. The supplemental record that Child and I filed with the court had an updated docket that includes a trial date for next week. That's my understanding.
And the trial's been continued a few times, right? This trial?
This particular review and redetermination?
Yes.
I
Well, anyway, that's fine. But can you speak to the argument that father's attorney is making about how far back this should go?
Yeah,
2020, 2023, what?
My position is that the court got it right in this case. The court looked for the time period specifically, and she makes a point of this in her findings and conclusion. She looked from June 2023 to May 2024, and that would encompass the time from the 2023 trial when there would have been a reasonable determination made.
What do you say to the argument father's attorney is making that there was actually, she couldn't find any finding at all that was actually made about reasonable efforts after the trial?
Sorry?
After the June 23 trial?
My understanding is finding 15, the court references the June 2023 trial and what the outcome of that was that it found that the department hadn't made reasonable efforts till that time, and there were consequences. And the consequences were the court did not terminate father's rights. And so from that point forward to May 24 is what the court was looking at the 29B hearing. And that was correct. That's not an abuse of discretion. That, I think, follows the principles of Rashida, that reasonable efforts determinations are made throughout a proceeding, and it's to see if reasonable efforts are being made for that period, and if they're not being made, to address that. And if they are being made, then it can determine that things are on track.
And how would you respond to Justice Shin's question to father's counsel about whether this issue on reasonable efforts is properly before us?
Yes, I argue in my brief that it is not, but I also recognize that there is a reading of 29BE that it could be. I think that where it gets very difficult is, as Justice Shin made the point, where if the principal appeal of the 29B hearing is dismissed, that the reasonable efforts tied to that would be dismissed too. And I think that there's language in Rashida that differentiates the sort of gravity, maybe for lack of a better word, that goes into a permanency hearing versus just a reasonable efforts determination. If the 29B encompassing both is out, then all that I think is left is a 29C reasonable efforts determination, which would not properly be before this court. But the language in 29BE does articulate orders and determinations, and since this court hasn't acted yet on the motion to dismiss the first argument, technically I think that there is, it could properly be before this court.
So let's say from the outset, the father was only challenging the part of the order concerning reasonable efforts, okay? Mm-hmm. Is that appealable to the full court under 29B, or does it go to the single justice?
I would say it goes to the single justice because of 29C.
Because of 29C.
You're saying just a reasonable efforts determination
It's part of the
hearing.
order, part of the permanency order, but the father only wants to challenge the part of the order that concerns reasonable efforts. That goes to the single justice and not full panel under 29B.
I think that there is, I think 29B can be interpreted that that is a determination from a 29B hearing.
Okay.
But I think then the next step that becomes difficult to piece together is what is it in relationship to reasonable efforts towards, it's married to what is going on in the permanency plan. And if there's not an objection to the permanency plan, it's sort of, I think, out of context. That's where the difficulty is, I think.
Do you agree with your opponent's position that the judge never found that the sexual abuse occurred while the child was living in the home?
No, my reading of the facts is that both children were removed, and that indicates they lived together, they were in the home. There's nothing.
But I believe what your opponent is saying is that they might have been removed for that reason, but there's no finding that the abuse itself occurred while the child was living there. It could have occurred, in other words, years before, before the child was born or something.
I don't think that's not how I read the findings. I don't think that there's, that's not my reading of it. I don't think that was the judge's intention, given the context of what she was ruling on. Just to make one more point about the time period, the timeline under review, that it wasn't an abuse of discretion to consider it the way the judge did, that what the judge did doesn't fall outside the range of reasonable alternatives. And there was no appeal of what took place in 2023 by father. Why would there be? It favored him. It made sense that the judge was looking at what took place since she found that there was no reasonable efforts in 2023.
And do you feel that if we did decide that it was this is reasonable efforts issue is appropriate before us, that the department, you're maintaining that that was reasonable, the number of visits that took place since June 2023?
Correct. What happened was 3 visits were made, 2 were attempted that didn't pan out because of father's circumstances, and that shouldn't be laid at the feet of the department. It was father's circumstances that interrupted the regular flow of visits, and the judge found that there was a scheduled visit post-hearing. So that's where, so I would say there were 6 visits or attempted visits over the course of 12 months.
Aren't the visits supposed to occur at least once a month?
That the regulations require regular and frequent.
Policy requires once a month, right?
Policy says once a month, but the regulations say regular and frequent. And I would say once every other month, which is what it averages out to, is regular and frequent. If there's no...
Yeah, I just have one more question. So why, and maybe you don't know the answer to this, was there not a permanency hearing between April of 2000 and May of 2004? It's the department, I would think you want, I mean, you have a child in your custody, right? And you want federal funding to, do you know why there was no?
Can you tell me the time frame?
From April, I believe, right? April 2000 and May 2004.
And what I have as far as the chronology is, there was a hearing held in April 2020, and then...
I'm sorry, I meant 2020, I apologize. Yeah, so 4 years, basically.
Okay, so in 2020, there was the hearing, and then there was a series of reschedulings of the permanency hearing throughout 2021, and it's not clear to me on the record
okay, so you don't know why.
Where that was prompted by. And then there was a reunification in 2022. There was a schedule there was a permanency hearing scheduled for February 2022. That was rescheduled, and then there was a reunification from April 2022 until October 2022.
Right, but even if there was a reunification,
No, I understand. I don't have a,
So you're
that's
not-
just
you don't
the
know the answer.
context.
Okay.
But I don't know where the source of causing the rescheduling was.
thank you.
Thank you, Your
Thank you. Mr. Dennis.
May it please the court, John Dennis, representing the child in substituted judgment. The child, my client, is 6.5 years old. He has autism and a developmental delay, and he's currently in a supportive placement. My role is to advocate what my client would choose if he were able to understand and weigh the options in this case. Based on the record and the child's circumstances, including the fact that father is incarcerated until 2030 for raping his sister, and that appeal is pending in this court at 23P 1238. My client's choice would be finality, not further litigation over prison visits. The child respectfully asked the court to affirm because first, the trial court found that DCF's efforts to reunify with father were reasonable based on the facts.
Counsel, can you address the issue? Father's counsel has indicated that she, do you feel that this reasonable efforts question is properly before the court?
Not when the permanency plan goes away. And I think it's supported. This is a complaint about services dressed up as a reasonable efforts complaint. Once the permanency plan goes away, the only thing father is contesting here is the number of visits he's getting, a service dispute. He's not seeking reunification. He doesn't speak at all to the plan for the child. He's only talking about his entitlement to visits. And that's something, if that were to be a full panel appeal every time a dispute over services arose, the delay would be, in finality for the child, would be unreasonable. In fact, there probably will be another appeal following the trial schedule next week, which would also delay finality for my client. So
You mean if the trial takes place and the...
If it takes place and then there's another
If the father's
appeal.
rights are terminated.
Right. And there's another appeal. So, and anyway, Rashida specifically gives the trial court and this court the discretion to characterize father's complaint as an abuse of discretion services complaint, not a reasonable efforts complaint based on the substance of what he's looking for. At 233 and 234 of the first Rashida opinion, it discusses that what the court should be looking at is the substance of what the father's looking for in characterizing the motion and what path of appeal it should be on. This one should be on a single justice path.
Can I ask you what you feel would be reasonable with respect to visits between your client and the father? What your position is on
You
that?
know, in the best interest of the child, I don't even think is fully aware, given his current, he's in the first grade, but he's very developmentally delayed, and he's not completely, the child's not benefiting and has no bond with the father. and the father's not seeking and never has sought reunification with the child. So there's no best interest of the child happening in these visits. There may even be harm, but the child hasn't objected. I can see that I'm running out of time, but I would, in closing, suggest that I don't think further litigation over prison visits with a father who's never sought reunification and is incarcerating for raping his sister should happen. It's no longer a live permanency appeal. Once the adoption plan was withdrawn and the father's appeal is dismissed, it's really a visitation complaint and an interlocutory appeal issue, which is properly resolved under Section 118.
Thank you. Thank you all. We'll take it under advisement. We're going to take a short break and then hear the last two cases.
All rise, please. Court is now in session. Please be seated.
The next case is 24P706, Mistler versus Lockheed Martin Corporation.
Good morning, Your Honors. May it please the Court, my name is Nina Callan, and I represent JOANNE Mistler, who's the appellant here and the plaintiff below. Your Honors, the issue in this case...
No, I'm sorry, did you file an appearance? Because my sheet has a different name. I just want to make sure that you're...
I'm Nina Callan, and I do have an appearance, and I'm listed as the person who's arguing.
Thank you.
The issue in this case is whether a defense contractor, a private corporation, should have absolute privilege and be absolutely immune with respect to any statements whatsoever that it makes about its employees and former employees in two types of government reports. This is an issue of first impression in both Massachusetts and the First Circuit, but we do have guidance from both jurisdictions, and I would ask you to follow that guidance. Massachusetts disfavors absolute immunity, and most recently, the United States...
In any context, or in...
well, it disfavors absolute immunity, which does not mean that there's never absolute immunity.
Well, it certainly doesn't disfavor it in cases involving judicial immunity.
That's correct.
Or a prosecutor working in their official capacity.
So here's an example. Many states allow absolute immunity for high government officials, such as a governor. Massachusetts, although it's never directly ruled on that, has indicated in several cases that it would not favor that type of immunity, and then has gone on to find those cases on different grounds. But there's many cases that say that, in general, Massachusetts disfavors absolute immunity. Now, that's in comparison to other states.
Well, can I ask you, you're not contesting that a state court can apply a federal common law immunity, right? I mean, you argue about the scope of the federal immunity, but you're not contesting that it can't be applied here.
So because this is a case of first impression in Massachusetts, this court is empowered to make a decision based on its judgment, and it can certainly take into account what other courts and jurisdictions have done.
Is this a question of state law or federal law? I don't read your brief to be contesting that a state court can apply federal common law immunity.
So there is no overriding federal common law immunity here. There's a case that said in the 1960s in the Fourth Circuit, hey, we're going to make up this immunity doctrine out of whole cloth, just to be clear. And there's some cases that follow that and some cases that put limits on it.
Common law immunity. So if this case was brought in federal court, the court would apply the common law immunity. So, I mean, it doesn't matter if the First Circuit has decided it. It's a federal, well, it might if it was brought in federal court, but to us, First Circuit, Fourth Circuit doesn't really matter as long as the state court can apply a federal common law immunity.
Where I'm disagreeing is that there is no across-the-board federal common law immunity in this context. So there is the Philco case, which again, back in the 1960s, reviewed a different set of regulations, not even regulations, just basically a memo, only applying to the JPAS NISPOM report, not even applying to the other report, which is at issue in this case. And the regulations that it interpreted are not the NISPOM regulations. There are very significant differences. So there are other federal jurisdictions which have adopted the reasoning of that case, but there are cases which I've cited which have not adopted the reasoning of that case. And
which is what the New Jersey case, the District of New Jersey case?
So I've got 3 cases which I've cited, or 4. So the Barron case versus Mission Solutions, which is New Jersey 2019, the Duval case, which is a 2008 case from South Carolina, the McNeil case, District of DC 2022, the Press case, which is Maryland 2018. So all of these put limits on the Becker case. And these are all cited in my briefs.
And these cases support your rumor and innuendo exception?
Some of them are on the basis of rumor and innuendo.
Which one?
I'm sorry?
Which one?
Give me a second.
Is that the New Jersey
The
case?
Barron case is rumor and innuendo.
That
The Duval case is rumor and
Was it
innuendo.
decided on that ground?
No, the Barron case was,
It was dicta, wasn't it?
I'm sorry?
It was dicta. Is that correct?
Yeah, I mean, first it decided on rumor and innuendo, and then it said, by the way, the statute of limitations applies. So technically, yes, it was dicta. But again, keeping in mind that the Becker case itself is not.
Do you have a case where it's not dicta? In other words, does the rumor and innuendo exception exist, other than in your brief?
The rumor and innuendo exception is in the NISPOM document itself. We didn't make it up. It's right there.
It's more like the trial judge, the motion judge said, excuse me, these are guidelines for what should be put in a complaint.
And that judge was following the Becker case, which he did not need to do because, again, it's not precedential in this district. It's not precedential in the First Circuit. It's not precedential in Massachusetts.
But it's extant federal law at the circuit level. And as the judge, if you create an exception for rumor and innuendo, why wouldn't that underline the public policy that lives within the Becker rule?
Well, the Becker rule made up, out of whole cloth, it made up this policy that a private corporation can defame its employees and get away with it, that it can say whatever it wants. There's no federal statute that
It's a balancing test, really, right? They're balancing the public policy needs to protect national security interests against a viable or not private suit claiming defamation.
Well, that should be the role of Congress. I mean, when Becker came down in the 1960s.
Well, other forms of immunity make the same calculation. We don't want judges spending their official time in court litigating claims from a disgruntled litigant who didn't like how they handled a case. And we don't want prosecutors spending their precious time in court defending civil lawsuits because of something they did or didn't say properly in court.
But this isn't about prosecutors. This is not about public employees.
No, my point is it's the same public policy that underlies both of those, that we don't want to create a chilling effect against what the judiciary or the prosecutors or what Lockheed Martin has to do under the DOD guidelines of what they have to present as an adverse information or whatever they called it.
So I disagree with that. I think there should be a chilling effect. I don't think that a private corporation should be empowered to tell really scurrilous lies about its employees for any reason whatsoever.
I don't know if the characterization of scurrilous is appropriate. They resolved it in her favor, but all they said is that she had her billing records were wrong.
But that's the point of absolute immunity, Your Honor, that the lies that are told in this case were that she overbilled her hours. But if you grant absolute immunity, it will affect whatever any private defense contractor wants to say about any of its employees.
I'm not sure that was actually, I thought you were challenging the part of the statements that she was terminated for overcharging and resigned before she could be interviewed for it.
So those are the facts of this case.
But are those not the only misstatements? You're also saying it was a misstatement to say that she, in fact, overcharged her hours? Because when I look at the report to the Department of Defense, there's an update. The last update says that they substantiated mischarging in the amount of 198 hours.
And then there's a lot that happened after that. So in the other document, the document that went to the Inspector General, the Department of the Navy conducted an investigation, thanks to the efforts of Attorney David Scott, who's here. And that investigation found that that Lockheed had told all kinds of lies, that it lied about that the overcharging was based on reports from my client's supervisor when it had never interviewed its supervisor, and it found that there was no evidence of mischarging whatsoever. There was no reasonable basis to find mischarging.
I don't read that letter the same way. I mean, it doesn't exonerate her. It just says based on the information currently before the decision maker.
Well, the exoneration is that it conducted I'm sorry, I didn't mean to interrupt.
Oh, I was just going to say, the letter from the Department of the Navy is from 2016. The last update in the report to the Department of Defense is in 2017, the one that says they've substantiated mischarging in the amount of 198 hours.
So just, again, there's two separate issues. One is the JPAS report, which the Department of Navy did not look at directly because that's not its job. It looked at the report to the Department of the Inspector General. Eventually, so what happens with the JPAS report is that a red flag is placed on the employee's file, which means that your security clearance is basically, it's basically gone. So with the help of, again, counsel, after 5 years, that red flag was removed. So in the meantime, my client's career was devastated. She's never going to recover from 5 years as a career defense contract employee.
Was she denied employment? Was she ever denied employment because of this?
So when she left Lockheed, she found another job immediately within a month or so.
And she didn't lose that job because she was debarred.
She did not lose that job. Well, first of all, she was never debarred. Again, that's the second report. After she was at that job for several months, she learned from her supervisor or from someone at that second job, hey, there's this red flag, which prevented her from fully participating in her job. It held her back. It meant that she could, so she bids on contracts, basically. She helps her employers bid on contracts for weapons. And she was unable to participate in that to a great extent while that red flag was on her record for 5 years. Again, something that she will never recover from. Her career will never fully recover from that. So going back to the question of federal common law, I would turn your attention to the case that I submitted to the court last week, which is a April 2025 case from the United States District Court from the District of Massachusetts. And that case was very similar to this one in that it had to do with reporting to a federal database. So a hospital reported to a federal database for medical providers, a database set up by Congress, that one of its doctors in its system was not meeting the standard of care. That doctor sued for defamation, and the hospital system defended on the grounds of absolute immunity. The district court for Massachusetts agreed with the hospital system, but that was based on statute. So there's a Massachusetts statute that says that reports to this particular database, this federal database, can never be brought into evidence, which, yeah, you can sue for defamation, but you'll never prove it. You're not going to have the evidence. So that's absolute immunity. And then there's also a federal statute that says that that a hospital system is immune unless it knew that what it said was false. And as a matter of fact, the court found that in that case, the hospital system did not know falsity. But again, grounded in statute, not in...
Do you have a federal circuit court case that rules contrary to Becker?
So the 4 cases that I said all limit Becker in various ways.
Say that?
The four courts that I stated earlier all limit Becker in various ways.
Those are district court cases, right?
Yeah, so you're asking
Do you
if
have
there...
any federal circuit court cases that limit Becker?
Not that I'm aware of.
Can I, this case has a unique procedural path, and you seem to make some claim, if I understood it correctly, that we should be reviewing this as a motion to dismiss, but the motion judge decided as a motion for summary judgment. And you didn't make any complaint, objection, or 56F continuation or request for more discovery. So you'll agree we're reviewing the allowed motion for summary judgment.
I mean, if you review it as a summary judgment motion, then you'll have to overturn it because Lockheed didn't submit any affidavits, it didn't submit any sworn testimony whatsoever. So it has no basis on summary judgment.
It's a question of law, though.
Well,
if they're entitled to judgment as a matter of law.
So if it's a question of law, then it doesn't matter whether you're reviewing it as a summary judgment standard, as a motion to dismiss standard.
I'm only raising it because you brought it up in your brief, and I just wanted to make sure I understood.
So I brought it up in my brief because Lockheed has argued that my client didn't submit sworn testimony in opposition to what Lockheed called a motion to dismiss / a motion in limine, which doesn't require sworn testimony. So I do want to make sure that this court understands that it wasn't submitted as a motion for summary judgment. It was submitted as something else altogether. And the court chose to say, hey, this is a motion for summary judgment, but that was for procedural reasons.
Okay, thank you. Mr. Albano.
Thank you.
May it please the court, my name is John Albano. With me is my partner, Siobhan Meade, my colleague, Josh Adler, and from Lockheed, Douglas Brown. The Superior Court's judgment dismissing this complaint, which I should add was preceded by 2 hearings in which the court made thoughtful and exceedingly fair comments to both sides, should be affirmed. With the court's permission, I would like to address 2 issues. First, just briefly, why the Superior Court was correct given the procedural posture of the case.
Can I interject
Yes.
a procedural question? When your first motion to dismiss was denied, it raised absolute immunity.
It did.
Which would have given you an interlocutory appeal rather than where we are now. But you didn't pursue that.
That's true, Your Honor.
I mean, it's not waived, I'm just curious.
Right, that's true. I assume the theory was that at the time that they would just proceed with the case, but I don't have any personal knowledge of that. So I'll first address the procedural issue because there seems to be a suggestion that the judge shouldn't have or couldn't have properly done what he did do. And I think there's 2 related points there. One is certainly well within the court's discretion to revisit the first ruling on the motion to dismiss, which, by the way, was treated as a motion for summary judgment. That's been the law since Peterson versus Hobson. Doesn't have to be the same judge. That's all well settled. The second point that the Superior Court also relied on was that the SJC has said this in the linkage case, that a trial court judge can revisit summary judgment at any time. And that's precisely what the judge did here. The last thing I'll say on this, it's not a citation to a case, but if you look at the record, 464 to 465 and 519 to 520, the judge's comments there about why he was engaging in this process, I think reflect the policies underlying Hobson and linkage, because he expressly said, I need to make sure this case is jury worthy. I'm going to have jurors who we expect to devote days of their lives to this. I'm going to have witnesses who are burdened with the case, and I'm going to have clients who are paying for attorney's fees. And I should, the court said, I'm paraphrasing him now, I should make sure this is all worth it, that this is, as he said, a jury-worthy case. And I think that is consistent. I would suggest that's consistent with the law. In terms of the merits, I would like to address 2 issues. First, that the judge was correct, that there's an absolute privilege here arising out of federal common law. And second, I would add that even if there's some type of exception from that absolute privilege, which I would say is kind of oxymoronic, is that the right term? It's an absolute privilege, it's an absolute privilege. But the plaintiff here, even assuming that there's some wiggle room there, did not show that any exception was warranted.
So could I ask you,
Yes.
state court, I mean, it's a little confusing because these cases normally come up in federal court. So a state court should be applying a federal common law immunity?
Yes.
And what are we looking at? Are we persuaded by the federal courts who apply this immunity? I mean, the Supreme Court hasn't said anything about it, right? So what is the standard that we apply?
So the judge mentioned the Superior Court judge mentioned in one of the hearings that he had read the SJC's case in Tosti versus AEC He called it Augustino a couple of times, but that's Tosti's first name. And that was a libel case involving a labor dispute. And the Supreme Judicial Court said, federal law says that if it's a libel case involving a labor dispute, the actual malice standard applies. So the judge thought, and I would suggest he's right, that if there is a state law claim that implicates federal common law, in this case, that, and here, of course, the obligation to make the report was under federal law.
What's the name of the SJC case?
Tosti, T-O-S-T-I,
T-O-S-T-I.
versus AYIK, A-Y-I-K. Analogous, because it's a labor dispute that gave rise to a defamation claim. And there are a couple of cases we've cited. I think it is Bridge Technology is a Virginia state court that applied the federal privilege, and the others are district court cases, I believe. In terms of the heart, though, of the judge's ruling, I would suggest he was correct to follow Becker. It is the only circuit court case to have addressed this issue. It has not been challenged in over 50 years. And I think it bears noting that the facts in Becker included that the report that was ruled privileged was made by a disgruntled employee. And what the fourth, so maybe some bias there. And what the court said, company has no discretion, mandatorily ordered to report, and that the privilege embraces both true and false accusations, both substantial and insubstantial suggestions. And the cases since then that we've cited, that I won't belabor the point, they're in the brief, are consistent with that. I would point out one case, the Bridge Technology case, which was, that's that case out of Virginia State Court. The court, there had been a suggestion raised that, well, maybe the rumor and innuendo language got inserted after Becker. And the Bridge Technology Court drilled down on that and said, nope, it was there in the language when Becker was decided. In my view, the closest case that really, there's one outlier. There's no other way to say it. It's Barron, I believe, right? And it is dicta. There's no way around it.
So what is the purpose of the rumor and innuendo language?
Well, what these courts have said is that, and the Superior Court as well, that it's to guide the reporting entity. So it's advice, guidance to the reporting entity, which makes sense because, remember, it's a mandatory reporting obligation, and if you screw up, you can be suspended from further federal contracts. So having some guidance that says rumor and innuendo you don't have to worry about, that I think makes sense and is helpful to federal contractors trying to balance this.
The contractor has the discretion to screen out issues that are based on a rumor and innuendo.
Well, certainly a contractor would say, I would look at it this way. If a contractor failed to make a report and the government said, we're suspending you from further federal contracts, that at least that contractor can say, well, hear me out on this. As the Superior Court judge said, he said something like, this isn't a case where someone just took the employee suggestion box and passed it on to the feds. And he was correct. This is not. This was a report. The heart of what the plaintiff says here is that what I call whistleblower, was out to get her. And I think that illustrates the need for the absolute privilege. Think of this. You're a federal contractor. You might lose millions of dollars of contracts if you fail to report an issue that you are concerned with. And you look, and if the rule is, well, there was animus on the part of the, what I'll call a whistleblower, what do they do then? They have to look into the soul of the person who made the report and determine whether it arises out of malice or out of a legitimate concern. Not to mention that we have in this case a 100-plus page report that was done after, investigation report after the
So
report
Becker
was made.
doesn't relate to the, doesn't concern a report to the Inspector General. In your view, is it broad enough to encompass that part of the claim as well, or is there a different circuit court case that's more on point?
I don't know of a different circuit court case. I would suggest that the answer there is because when you look at that federal acquisition regulations and you see that that too is a mandatory reporting obligation, that is the reason why all of Becker's rationale applies to the FAR report.
What ended in the end? What was incorrect as far as what was reported? The improper billing records, or that she was fired because of it?
So I think there's three issues there. There's the first report said her employment had been terminated. Now, you know, I went back to Merriam-Webster, and terminated does include ending, the end of a relationship. But in order to...
It implies something very different, though.
Right. In order to clarify any misunderstanding, the company said, we're going to supplement this and point out that, which is true, she resigned. She was not terminated. So that's one issue they say is false. There's some controversy about, which the plaintiff has claimed, and that's her claim, that she had no knowledge of the investigation at the time. So there's part of the phrasing the plaintiff takes issue with there, and the plaintiff certainly takes issue with the overcharging, but none of that is, the overcharging is certainly not conceded by Lockheed Martin, and that's the heart of the reason for their action and why they...
And they paid a fine.
Defending it.
$250,000? I mean reimbursement, excuse me,
right.
wrong word.
There is a reimbursement, and that is, there's two places in the record you can see that.
And DOD didn't give that money back based on more accounting?
Yes, yes. And there's a reference to it in, I believe it's the FAR decision that's technically written by the Secretary of Navy, I think, certainly the Department of Navy. And we also filed in the court aloud a motion to supplement the record appendix in this case to include the joint trial exhibits that were joint trial exhibits that reflected the reimbursement of the calculated.
But you would maintain that regardless of the accuracy of the company's findings, they still have absolute immunity?
Absolutely. I mean, it's quite analogous to, well, we all have a privilege here today, right? Someone just got up and said Lockheed did terrible things. Counsel is absolutely privileged to say that, and that's so that she can freely speak and advocate for her client. And it's very similar rationale here under the federal common law that we have, look, okay, this isn't, and I'm not being flip here. This isn't like a debate about, you know, did the Atlantic editor have animus against the Secretary of Defense when reporting on security risks in Signal, on a Signal chat line. It's not that. It's a federal contractor who has a mandatory obligation to alert the government to these types of concerns. And I don't think, and the Superior Court said this many times, there's nothing here denigrates the plaintiff's claims. They just simply fail as a matter of law. And
why is there such a discrepancy between the number of hours reported in the two different reports?
I'm sorry, Your Honor?
Why is there such a discrepancy? So in the letter to the Inspector General, it says conservatively it's 1,907 hours. And then in the report to the Department of Defense, it says 198 hours. Why is there such a discrepancy?
I have to admit, I missed that. Okay. My counsel tells me it's reflecting different periods of time. I'm sorry, I didn't realize that. I'm almost out of time. The only thing I would add is that I thought on
You actually are out of time, though.
Oh, I am. Sorry.
All right.
Thank you.
Thank you. Thank you all. We'll take it under advisement. Our last case is 24P861, Gary Sawyer versus the town of Barnstable. Mr. Panabianco. Did I say it correctly?
Yes. Good morning, Your Honors, and may it please the Court. Attorney Anthony Panabianco on behalf of the appellant and plaintiff in this matter, Gary Sawyer. What we have here is a summary judgment decision from the Superior Court in Barnstable that we're asking here to reverse and remand. It is a very simplistic case, we argue. While my brothers here would like to point to lots of information and design aspects to make it confusing for the court, we would like to strip that all away, and we do believe our complaint strips that all away.
Let me see if I can strike some things out of the way.
Sure.
Why isn't this barred by the public duty rule codified in Section 10J of 258?
Two reasons, Your Honor, for that. One, that was not part of this summary judgment determination. It was reserved because it didn't need to get to that point in.
It was raised, though.
It was raised, but not determined by the opinion.
Oh, it's in a footnote. The judge said they also win based on immunity under 10B and 10J.
Yeah. Yes, and we think that's incorrect, Your Honor. But
it's incorrectly ruled on it, or they came to the wrong conclusion?
I think that's both, Your Honor, if I may. You can look to our summary judgment papers in and of itself.
Well, all right, just tell me why 10J doesn't make this go away.
Pardon?
Tell me why 10J didn't require the dismissal of this suit.
Because it doesn't require dismissal of the suit for the either CEI, who's not applicable for that, the individual defendant, or the town of Barnstable, because we don't believe that the discretionary features of...
No, I'm talking 10J, not 10B.
I don't think that the public policy that would be relevant herein...
10J provides immunity for any claim based on the failure to act or prevent or diminish the harmful consequences of a condition not caused by the public employer.
Yes, and there's exceptions to that. And one of the exceptions to that would be gross negligence, which we believe...
That's a separate cause of action. That's not an exception.
It is a separate cause of action that's over and above that, but I don't think 10J...
The immunities under Section 10 are independent of one another.
Yeah, I understand that, Your Honor, and I don't think that 10J applies in the particular fact pattern of circumstances that we have here, where there is a known malfunctioning device, essentially a malfunctioning OEM that was set up...
They failed to prevent the flooding. That's what the allegation is.
They failed to prevent the flooding, and...
They didn't cause the flood.
disagree, Your Honor.
They control the weather?
No, they don't control the weather, Your Honor, but flooding is a result of rain. They don't control the rain, they control the result of what happens to that rain.
So that's the failure to prevent or diminish harmful consequences of the rain.
Yes, failure to prevent that through both from the design standpoint of CEI, which is outside the scope of the 10J consideration, but the town's consideration as to what is known throughout the time period of the design before the maintenance program was developed and then transferred over to them.
They were negligent in failing to prevent the harmful consequences that occurred after the rain.
That occurred during the rain.
I meant that as a yes or no.
Yes, it occurred yes, but during
that's what 10J provides immunity for.
And for the purposes of this 10J wouldn't apply because of the number of factors that go into the, not just public policy, but the ownership of land that would require any owner, whether it's a public or private individual.
It has to be an affirmative act by the public employer.
And it was an affirmative act in this regard. Their affirmative act doesn't mean that they have to go forward and cause the spill, as you were alluding to earlier, and create the rain. Affirmative act can be the failure to maintain the OEM procedures that they're required to do. The affirmative act can be the installation of a known, as they admit in their OEM.
SJC said in Brum that would, if that were the rule, that would swallow the exception. You can't say that the failure to do something is the affirmative act, because by very addition, it's the failure to do something is an omission.
And as I was stating at the conclusion there, it's not just that, it was the creation of that BMP at a gradient that the town determined to do so, that would, essentially it surrounds my client's properties at a higher gradient, creating stormwater runoff. That's an affirmative act of creating that particular and designing and
I don't want to take up your time, go ahead.
That's okay, I understand.
Could I ask you about your claim against CEI?
Pardon?
I'm going to ask you about your claim against CEI.
Certainly.
So you have an extraordinary storm event, and in order to make out a claim for negligence, you have to prove that CEI's negligent design or construction, that's what you're alleging, right? That they negligently designed the project, that the flooding would have occurred, would not have occurred but for their negligence. How is a jury supposed to decide that without expert testimony?
Easily, Your Honor, and I'll go back to the very first point that you stated, that we don't believe it to be an extraordinary event. You look to the 2.92 inches of rain that occurred at that time over the course of 3 hours. It is similar in nature to the 1 hour per 1 inch that occurred during the failure while they were designing and building it, that they were aware of. You look to their own language of known abnormalities in their OEM. After a failure where, quote, a large storm was observed to have occurred over a very short duration, approximately 1 inch of rainfall within 1 hour, because this subcatchment is approximately 50% impervious cover, this resulted in enormously high peak volume. Grass clippings from the BMP had become trapped, creating a partial blockage of the emergency overflow.
What are you reading from?
It's from the OEM. It's RAI, page 14.
RA...
Record Appendix 1, sorry. Record Appendix 1.
Page 14 of Record Appendix 1?
Yes.
Is it a res ipsa loquitur claim?
Yes, if not for the creation of these, of this development by the town through CEI's design, which they acknowledge in their own OEM as flawed, it would not have created this. My client held the property from 2000, still does, but 2008 to 2017 without issue. It was only until the implementation of this design system that then created flooding on the property. It sits, as we allege in the complaint and acknowledge in the paperwork, and they acknowledge in their own, that there are space constraints for this retrofitted project. Typical sediment forebay could not be constructed. That's in Record Appendix 1, page 16. the system is designed to surcharge before entering the BMP. That means coming from the top of the street down through the system. It is possible that sediment could accumulate in the deep sump pump manhole, potentially impact stormwater flow capacity. That's, again, Record Appendix page 16. That's their language, not mine. It's not our allegations. It's not our words that we're trying to describe to a layman. It is CEI's own words to the town saying, we designed this, retrofitted one that we know is going to have problems unless these things exist. And those problems can occur with 1 inch of rain over an hour. That was well prior to the rain event that actually caused the flooding and storm to my client's property. So they knew while going into this project that it was undersized, that it had the potential for abnormalities, yet they went through with it anyway, and they failed to maintain it. The maintenance is alleged both from CEI and the town. In both complaints, both causes of claim against CEI and the town, we allege that there's a failure to maintain. As the town's own paperwork alleges, it's a question of fact, essentially, as to when the handover of maintenance occurred. The OEM, which is the operational for management, was in February of 2016. The town alleges it didn't happen, and the transfer didn't happen until late in 2017, and the incident in question happened in July of 2017. So that's a question of fact for the jury as to whose duty it was at that time to maintain. There is no question that there was a duty to maintain. CEI would admit to it, the town would admit to it, and they do in their papers. It's whether or not that rises to the level of what occurred here. We think that this case is analogous to the Gillis case. Very quickly, we'll go into that. What the court said there is that a lay individual can make a determination that because there was no rain events, no flooding events prior to this town development, we can make the exception, or we can make the understanding, a layperson can, that that's the cause of it. We don't that is cause A of the flooding. We don't have to get into the possibilities of B through Z. So the same issue here. Here, if you extrapolate it into Gillis, Gillis was looking at a nuisance issue. It's the same consideration here that in Gillis a berm was removed, a layperson can see that a berm was removed and say this caused the flooding and it would not happen but for what occurred here. From 2008 to 2017, my client owned the property without a single flooding instance. The judgment affirms that. There's no dispute of that. It was only once they installed this program, this BMP program, which they acknowledge was undersized, which they acknowledge can't capture rain above 1 inch within an hour, which is a commonality that they observed prior to essentially going online with the project. A layman can understand that.
It was 2 years after they installed it, right, when the flooding occurred? So there was no flooding for 2 years after installation, and we have there's no evidence in the record about what happened after the flooding event.
I'll answer that in two parts. It wasn't concluded with construction in 2015. There was still landscaping and other development of the project in 2015 and 16. The OEM maintenance plan is questioned between the parties whether or not the maintenance of it was in 2016, 2017. It was written in 2016. So there was no flooding in that time period, but the initial that caused the case here occurred in 2017. I would like to just be brief on CEI's case law, if I may have a moment here. They do cite from their particular case, LeBlanc versus Logan, about what they cite is expert testimonies generally needed to establish the professional standard of care. However, in that particular case, that case which they don't cite, they don't acknowledge in their paperwork, was actually remanded on appeal. In that, that case goes into the appeal that it's distinct from the expert opinion needed there for architectural parties, which is different here. We're not arguing an architectural issue. It is they knew and designed it, acknowledged these failures, and then let it continue to go. But in LeBlanc, an electrician suffered personal injury by reason of an unlabeled electrical distribution panel, and the court said, yes, let's remand that to determine whether or not that's a signposting acknowledging that it's a dangerous system. Because of that it didn't need an expert opinion. That's what the court ultimately determined. Here, we can take it one step further in the sense that we already know that it was dangerous. We don't need a label warning for it. The OEM that CEI drafted states that it's a dangerous process that would overflow. It's an undersized unit and would overflow in certain circumstances, which they observed to occur prior to the flooding on my client's property. So we're already past the point of the one truly powerful case that they wanted to cite in their paperwork, LeBlanc versus Logan. So I don't think that's applicable here. I don't think that you can distinguish Gillis from the case at fact here in that bring it down to the most simple level. Did the client have any flooding? Did the property have any flooding from 2008 to 2017? It did not. The conclusion of the property that CEI and the town implemented next to my client's property occurred throughout that time period and concluded around 2015-16 with additional work being done. And then immediately upon the next rainstorm, it flooded, causing significant damages. A layperson can make that determination factor simply by looking at CEI's own words, acknowledging their failures and acknowledging the deficits of their design, requiring the town to do certain things that they did not do. There's no argument that they did. It does not take an expert to look at their own words. They've already admitted it, and we're asking that the court allow a jury to acknowledge that and reverse.
Thank you. Thank you. Mr. Edwards.
If it may please the court, I'm John Edwards, and I represent Comprehensive Environmental, who everyone is referring to as CEI. I refer to as CEI. Listening to my brother's arguments, I heard some things that I've never heard, either in the appellate briefing or in the briefing below, about elements of language found in the OEM plan that was drafted after the BMP project had been built and was functioning. And we would take the position that any arguments that could be made off of those particular pages cited in the appendix have been waived by failure to argue it at any point up until today. In any event, it doesn't change the outcome. In fact, it buttresses the outcome of the probity and correctness of the trial court's ruling. The crux of the plaintiff's argument is very simple, really, and you can see it in the argument itself that runs briefly. It's one sentence from page 13 to 14. And this is the only argument that's been made by plaintiff, either to the trial court or to the appellate court. However, the plaintiff has made no claim, nor need to, as to the applicable engineering standards, and we're talking about the applicable engineering standards used by my client, CEI, in designing the BMP project. And the position has been, instead, all that the plaintiff needs to show is that but for the installation of the BMP project, its design and construction, the plaintiff would never have suffered any flooding. He points out, the plaintiff, there was no flooding to his property prior to the BMP, and for the sake of the record here today, we're not disputing that there was. And then after that the BMP was installed, there was a flood. And it is important to emphasize there is evidence in this record of only one flood. 2 years after the BMP was constructed, there was some questioning as to, or there was some suggestion that the BMP in fact wasn't complete in 2015. There's no evidence in the record that that is so. The only thing that hadn't been done by 2015, which was completed in early 2016, was some landscaping and the drafting of the OEM. The BMP project was functional in 2015.
Counsel, how do you distinguish the Gillis case?
Well, there's two bases fundamentally upon which to distinguish Gillis. First, the Gillis case is not a case that turned on tort principles of negligence, in this case, the negligence of a professional in the design of a complex engineering project. In fact, it was a nuisance case. That's what it was. As a result, the elements of proof that the plaintiff had to satisfy, to get a case to the jury, were different than the elements of proof that the plaintiff must satisfy to get to a jury in this case.
They still had to prove causation to get to the jury.
I'm sorry?
They still had to prove causation to get to the jury.
Of course, you're right, and that is something that has to be proven in this case as well. But first, it must be shown that in the case of comprehensive environmental, that the design did not meet the standards of a reasonable professional in their field doing an application like this in a setting like this. That is the first and threshold question, and it is completely ignored by Mr. Sawyer when he presents his arguments. Gillis did not have to consider that particular issue. All that mattered was, could it be established that the work that was done by the town in that case, did it cause the flooding that persistently occurred after the grading work was done? That was it. This court, the trial court, has to answer two questions, and the first threshold question hasn't even been addressed by the plaintiff. And it is fairly well settled law in this jurisdiction that that particular question, absent extraordinary circumstances and evidence, is something that can only be presented to a jury through an expert witness, that the plaintiff can't sustain his or her burden absent that kind of testimony. And this is precisely the kind of case in which that kind of testimony is necessary. There is absolutely no evidence, no suggestion, really, as to precisely how and in what manner the design itself created the conditions that the plaintiff now complains of, that the plaintiff says caused the flooding on July 7th of 2017. And without it, there's nothing that a jury nothing can be put to a jury that would enable the jury to decide. Now, in addition to that distinction, there is a very different set of facts. We have one flood event. That is it. Across the arc now of almost 10 years. That is very different than the persistent, frequent flooding that took place after the work was done in the Gillis case. You simply don't have that fact pattern here. And that fact pattern in the Gillis case was in my view of reading the case, critical to the court's ultimate determination on the question of, as Your Honor pointed out, causation. But we don't ever get to the causation question, even if it were applicable, without addressing the question of, was there a standard of care that CEI in fact breached when it did the work? And there's no evidence whatsoever in the record, and there really can't be under Massachusetts law without the benefit of an expert looking at the design work. And with that, I see I'm running low on time, and if you have any further questions, otherwise.
Seeing none. Thank you.
Thank you.
Mr. Farrencourt.
May it please the court. Good afternoon, Your Honor. Cole Farrencourt for the town of Barnstable. Justice Meade, just to begin, I would like to follow up on a point you made earlier in your questioning. Here, the town is immune from suit pursuant to Section 10J of the Massachusetts Tort Claims Act. That is because Mr. Sawyer's claim here is based on the town's alleged failure to prevent harm, that is, the flooding of his property. However, the record is devoid of any affirmative acts that materially contributed to the flooding such that the town was not the original cause. The exceptions to 10J, I think my brother attempts to rely on
10J3.
10J3 as to negligent maintenance of property, of public property. Your Honor, first, the undisputed record reflects that the town had not taken ownership of the property at the point in time when this flooding occurred. I believe that was July 7, 2017. But in addition to that, Your Honor, at Mr. Sawyer's deposition, he testified that the cause of the flooding at his property was not maintenance of the system, but rather the design of the system. He claims that the design was deficient. So where Mr. Sawyer himself testified that that the cause was not maintenance, he cannot come back before this court now and claim that it actually was maintenance such that 10J3 saves his claim. We would also note that Mr. Sawyer has waived those arguments by failing to raise them in his papers before this court. Those arguments and the immunities were addressed by, or at least recognized by Judge Perino in his decision below. They were not addressed in Mr. Sawyer's principal brief before this court. After the town addressed them in our brief, Mr. Sawyer had the opportunity to file a reply brief, but he did not do so. Where he has not put those issues before this court or attempted to refute them, Mr. Sawyer has waived those arguments. In addition to 10J, the town is also immune pursuant to Section 10B, the discretionary function exception. To the extent that Mr. Sawyer's claim is predicated upon the design or decision to install the BMP, those are discretionary decisions that require high-level policymaking. The town has to review several different alternatives and ultimately reach a conclusion as to whether installing such a system would be feasible, would promote public health, and would be in the interest of the community. Here, those are other circumstances. It was a difficult decision, and as such, the town is immune from suit pursuant to Section 10B. In addition to the town's immunities, as my brother Mr. Edwards referenced earlier, the plaintiff's claim cannot succeed where he lacks expert testimony on the issue of causation. Mr. Sawyer attempts to rely on this court's holding in Gillis v. Town of Uxbridge, which, as Mr. Edwards earlier distinguished, it's a very different set of facts. In Gillis, there was no flooding, followed by the removal of a berm, and then significant regular flooding. Those aren't the facts that we are presented with here. There's no evidence of flooding from 2008 until 2017. There is evidence of a single flood, the July 2017 event, and there's no evidence of any additional flooding after that. Where Gillis presented an easy before and after scenario, this case is much different. Additionally, it seems that this court had considered a possibility of such a case as this one when drafting the decision in Gillis. I believe his footnote 4 references the fact that there were no alternative, or there was no evidence of any alternative causes in the record in the Gillis case. Here, we have presented evidence of a significant storm bringing approximately 3 inches of rain in as many hours, about an inch per hour, that caused this event, this flooding event, Mr. Sawyer's property. If there are no questions, we'll rest on our brief.
Seeing none, thank you.
Thank you.
Thank you all. With that, I'd like to thank my panel, our law clerks, our court staff, our clerk's office, and our excellent timekeeper, and we will stand in recess.